This is a lecture for professional responsibility, and we're going to be talking about a recent ABA ethics opinion about judges doing their own independent factual research on the internet. This is Formal Opinion 478 from the American Bar Association, and that was put out in 2017. Of all of the recent ABA ethics opinions about judges, this is the one that seems to be tested the most on the MPRE, and I'm going to do, that's why I'm doing a separate lecture on this for my students to make sure you're familiar with it. Also, this lecture is I'm going to spend some time going through this. By the way, for my students, this is a very well-written opinion that goes through hypothetical questions and answers that are, and this may be part of the reason that this is tested so much by on the MPRE. The opinion itself has a set of 5 hypotheticals that are super easy to turn into multiple choice questions. And so this is should be your top priority as far as the, it's not the only one you should look at, but should be the highest priority in studying for the MPRE of the recent ABA ethics opinions about judges. So first, the opinion goes through a few provisions of the Code of Judicial Conduct, but the most relevant one is going to be 2.9c. So the Model Code of Judicial Conduct, and sorry for the little stray asterisks there, has a rule on ex parte communication that includes a provision that specifically addresses independent investigation of facts. And so the Code of Judicial Conduct Rule 2.9c states a judge shall not investigate facts in a matter independently and shall consider only the evidence presented and any facts that may properly be judicially noticed. And so just to stop here for a second, pause. Before we talk about the internet, I want to make sure my students understand this. Let's say we have a judge presiding over a trial about a traffic accident, and the party's stories or description of the intersection where the accident occurred are contradictory. They don't make any sense. So the judge decides to get in his or her car one evening and go to the location, to the intersection where the accident occurred, and look at it for herself. And you can't do that. Judges are not allowed to do that. You have to rely on the factual information and evidence that's in the record submitted by the parties, and that has gone through the vetting of the other parties, being challenged for admissibility and so forth. The same is true if we have let's say, a medical malpractice case or something like that. The judge can't go and interview doctors and get a second and third and fourth opinion if the judge finds that the two parties have experts testifying who contradict each other, which is often the case. So the judge can't do independent factual research like in real space and time, nor can they do so using the internet. Comment 6 to Rule 2.9 clarifies that the prohibition against a judge investigating the facts in a manner extends to information available in all mediums, including electronic. Now, please note an important exclusion. This does not preclude legal research. 2.9c carefully prescribes independent research of facts. Judges may conduct legal research beyond the cases and authorities cited or provided by counsel. For my students, make sure you understand that. That is something that could easily be tested as a kind of gotcha question on a multiple choice exam. So the judge isn't sure that either of the parties have really looked for all of the precedent or have really looked for checked for relevant statutes about a matter. It can happen. Sometimes there's lawyers who kind of don't do any research, and sometimes it could be both lawyers in a given case haven't really done their research. It could be that very common that you'll have a firm where people at the firm are recycling each other's briefs or copying and pasting from briefs from other lawyers at the firm and haven't really done their own internet research. And so judges have clerks, and a lot of times the clerks are actually supposed to take the parties' briefs, read them, and then do searches on Westlaw and Lexis to see if there's other case law out there or relevant statutes, let's say, or constitutional provisions or things like that, relevant regulations that the parties have overlooked or maybe strategically neglected to mention. So if it's legal authority, judges are allowed to do that, but they can't do fact searches. 2.9D requires that judges take steps to prevent court staff and officials from performing improper independent investigations. The rule provides a judge shall make reasonable efforts, including providing appropriate supervision to ensure that the rule is not violated by court staff, court officials, and others subject to the judge's discretion and control. And who are we really talking about here? The judge's clerks. And so if if there's a judicial clerk, we really don't want judicial clerks visiting the scene of the accident and looking at it for themselves. If it's a dispute over a boundary line between neighboring property owners, we don't want the judge's clerks going out and inspecting it themselves, the site themselves, and so forth. Now, something that's very funny, as I'm recording this, it has my little video kind of on my screen right where the judge would be sitting behind that bench, which is funny. Okay, this opinion sets forth a little list of guidelines for the judge to ask himself or herself in deciding this. Why? Because judges are allowed to take judicial notice of established facts. In other words, if the parties forget to brief or supply evidence that the sky is blue, or that that April 21st, 2020 is a Tuesday, or something like that, the judge can just take judicial notice of this, and this will usually be put on the record of the trial. I am hereby taking judicial notice of this. Very often the lawyers have a chance to object if they want. They're going to look pretty silly if they do. What I tell my law students is, what types of things can the judge take judicial notice of? Our classic is almanac type information. The type of information that's in the almanac, like what a day of the week was a certain date in recent history, or what phase of the moon, was there a full moon last Thursday, and things like that. What day of the week was Christmas in 1998? So these are types of facts that reasonable people can't dispute. We're not talking about something like macroeconomic policy, or which branch of government is the most important or most necessary to keep in check in a democracy, things that experts are going to be debating about until the end of time. Now, we're kind of talking about just agreed upon facts. Okay, so first, is additional information necessary to decide the case? If so, this type of information generally must be provided by counsel or the parties, and must be subject to proper judicial notice. So this means that if it's a fact needed that would really be helpful in deciding the case, the party should provide it, or the judge should follow appropriate procedures for announcing that they're taking this on as a matter of judicial notice, and it gets put in the record and the parties are given an opportunity to object and so forth. 2, is the purpose of the judge's inquiry to corroborate facts or discredit facts or fill a factual gap in the record? If the facts are adjudicative, it is improper for a judge to do so. Next, is the judge seeking general or educational information that is useful to provide the judge with a better understanding of a subject matter unrelated to a pending or impending case? If so, that type of inquiry is usually appropriate. So that's okay. Judges may use the internet as they would other educational sources like judicial seminars and books. And so let's say as a judge that you are you're curious and you want to learn about something like the way ocean tides work, or the climate change is affecting Greenland or something like that, or you've always wondered about magnets and how magnets work. I'm giving a silly example. So you missed that day in school growing up when they explained magnets, and so you go on the internet one day and go to Wikipedia and start kind of going down the rabbit hole of clicking through links and stuff like that, and before you know it, you're reading about about primitive peoples and cave dwellers and the Battle of Hastings and all sorts of stuff, and you started researching about magnets. Are judges allowed to do that? Sure, you're allowed to do that. And you want to kind of get up to snuff on something like how does the stock market work, or what are bundled derivatives or something, read up on that to your heart's content. Now, is the judge seeking background information about a party or a subject matter of pending or impending case? If so, this may represent adjudicative facts or legislative facts, depending on the circumstances. And the key inquiry is whether the information to be gathered is of a factual consequence in determining the case. If it is, it must be subject to testing through the adversary process. And so I'm going to give a quick example here. A judge has been doing cases. You've been a judge for a while, and you get to know the lawyers who litigate in your courthouse pretty well, and all of a sudden you get a pro hoc vici appearance in a case from an out-of-state lawyer who you've never heard of. And so you decide to check them out. You go to their website and their law firm's website and see who they are and how long they've been practicing and where they went to law school and stuff like that. That's it. If this is just to kind of familiarize yourself with the new lawyer that's going to be showing up in your courtroom, but isn't really something that's going to influence how you decide the case, then that's probably okay. You want to get to know a lawyer, or you think, oh wait, I knew somebody by that name in law school. I wonder if it's the same guy, and you look it up and it's not the same guy. No harm done, right? That's okay. On the other hand, if you have heard, oh, this lawyer's a scoundrel, or this is a very controversial attorney or something, and so you start reading up on it so that you can be watchful and keep an eye on that guy at trial, that's a little different. Okay, so here's the first of our hypotheticals. Hypothetical number one. In a proceeding before the judge, in a case involving overtime pay, defendant's counsel explains that the plaintiff could not have worked more than 40 hours per week because the defendant's restaurant is in an industrial area and only open for, it's supposed to say breakfast, sorry, that's a typo, and lunch during the work week and not on weekends. The judge is familiar with the area and skeptical of counsel's claims, and the judge checks websites like Yelp and Google Maps, which list the restaurant as being open 7 a.m. to 10 p.m. 7 days a week. Does this search violate 2.9c of the Model Code of Judicial Conduct? And the answer is it does. You're not allowed to do that. This search violates 2.9c because the restaurant's hours of operation are key to whether the plaintiff could prevail in a claim of unpaid overtime. And so you should ask the parties and their counsel to provide admissible evidence about the restaurant's hours of operation. Please note for my students, hit pause for a moment. It is okay for a judge to say, you know what, I need a little more facts on this. I'd like the parties to submit briefing and evidence, if you could, about this question, because it's going to affect how I decide the case. Like, what are the restaurant's hours of operation? That's very relevant to a question of overtime pay. A lawsuit over overtime pay, ask the parties to submit evidence. Don't go looking it up yourself. Okay, hypothetical number two. The judicial district in which the judge is assigned has many environmental contamination cases involving allegations that toxic chemicals have been released and have contaminated soil and groundwater. The judge is unfamiliar with this area of environmental law. Before a case is assigned to the judge reads online background information, including some articles. So just to paraphrase what we just read here, this is a court, and they're kind of put on notice that, or a judge is put on notice that they're going to get a big pile of toxic tort cases. This, by the way, is kind of common. And so, for example, The federal court in Houston from time to time sort of gets notice that there's a number of cases that are going to be transferred from another district of Texas, or that there's been a law, and so there's going to be kind of a wave of a certain type of prisoner appeals because of a Supreme Court case or something like that. And so a judge who doesn't know the area wants to kind of get familiar with the terminology and so forth. And let's see what we say. That is okay. That is okay. So let's say, I'll give another example. The judge gets a new assignment, gets assigned to a particular courthouse, and that courthouse has a lot of intellectual property cases. And please note that intellectual property cases are not evenly distributed across courts in the United States. And the same is true for immigration cases or oil and gas cases and things like that. They're not necessarily distributed evenly. So if a judge realizes, wow, I don't know anything about IP law, and all of a sudden I'm going to have to have a lot of IP cases assigned to my courtroom and my docket, I better read up on this a little bit. And the same could be true if there's sort of an avalanche of civil rights cases or a type of immigration claims or something like that. So judges can educate themselves by independent research about general topics of interest, even on topics that are going to come before the judge. General background learning on the internet may be analogized to attending judicial seminars or reading books, so long as there's reason to believe the source is reliable. Now, even so, this type of subject area is not permissible if the judge is acquiring information to make an adjudicative decision of material fact. And so if you're reading up on this so that you can adopt a position about whether we should restrict fracking or encourage fracking, and you're going to go into the cases with your mind made up of fracking yay or nay, that's not allowed. On the other hand, if you find out you're going to have a whole bunch of litigation over fracking assigned to your courtroom and you're kind of unclear on what that even is, and so you want to read up on it so that you're familiar with the terminology and you don't feel silly or say stupid things, make a fool out of yourself in court, that is okay. Okay, hypothetical 3. A social media savvy lawyer has just been appointed to the bench. Before being appointed, the lawyer used social media to conduct extensive background research on potential jurors and opposing parties. Now, the judge has been assigned to hear a complex multi-party case involving lawyers from out of state. The judge wants to review social media websites of each of the parties and the out-of-state lawyers to learn background information about the parties, to read the lawyer's writings, to review a list of the lawyer's current and former clients. Does this action violate 2.9c of the Code of Judicial Conduct? Probably this does. I know I said it's one thing if the judge has never heard of a lawyer before and wants to figure out, check this person and make sure, or something like that, that's one thing. But while the Model Code of Judicial Conduct does not prohibit a judge from personally participating in social media, electronic social media, which we call ESM, a judge must avoid using any ESM site to obtain information regarding a matter before the judge. Online research to gather information about a juror or party in a pending or impending case is independent factual research. So you shouldn't be researching jurors, you shouldn't be researching parties. And actually, I don't think it's a question of how much research you can do about the lawyer. I suspect that a superficial check about a lawyer, like what kind of firm do they work for or something like that, is one thing. But if you are like reading the lawyer's prior writings, trying to figure out if this lawyer has a great track record or something, pretty quickly you've crossed a line because it's going to influence how you treat that lawyer. So here we go. The judge's information gathering about a lawyer may be permissible if it is done merely to become familiar with counsel who appear before the court, similar to how a judge may have in the past reviewed a legal directory like Martindale-Hubbell, or to determine whether the lawyer is authorized to practice in a jurisdiction. That's what I'm talking about. However, the judge's independent research about a lawyer is not permitted if it is done to affect the judge's weighing or considering of adjudicative facts. If an otherwise permissible review results in a judge obtaining information about the existence or veracity of adjudicative facts in the matter, the judge should ask the parties to address the facts in the proceeding through evidentiary submissions. Okay, fourth hypothetical, we're almost done. A trial judge presiding over an owner's claim for insurance coverage heard testimony from competing experts about their investigation and opinions about the cause of a fire that destroyed the plaintiff's property. While preparing findings of fact and conclusions of law, the judge received summaries her law clerk created from journals and articles on the proper techniques and analysis for investigating fires of unknown origin. In other words, we hired two experts who do fire scene investigations, arson investigations. They completely contradicted each other. So the judge's clerk does some research on best practices for arson investigations and writes a little memo so the judge knows basically how much weight to give each expert's opinion. And this is prohibited. By searching the internet for journals and articles on investigating fires, the law clerk engaged in an improper independent factual investigation. The method and extent of the expert's investigation is an issue in dispute. That is, it's an adjudicative fact. The respective experts' investigative methods related directly to the weight and credibility given of the testimony concerning an adjudicative fact and fall within the prohibition in 2.9c. The trial court, therefore, could not take judicial notice of these things as being not subject to reasonable dispute, because obviously we have experts who are disputing it, and because they're neither generally known within the trial court's jurisdiction, nor can they be accurately or readily determined from sources. So these are our standards for taking judicial notice. Okay, enough about that. I'm going to go on to hypothetical 5. And if you want more detail on this, you can read the opinion, but I'm worried about making this video too long. To render an accurate decision in a pending matter, a judge needs to know whether a party is or was the subject of other judicial proceedings. The judge searches the court's electronic files of the other cases and facts in each case, including sealed information. The search reveals several other cases, some pending and some concluded, and some within and some outside of the judge's jurisdiction. Does the judge's search violate 2.9c of the Code of Judicial Conduct? And so here, this is mostly okay. 2.9c does not prohibit consideration of facts that may be properly judicially noticed. And so, for example, a judge may take judicial notice of a guilty plea entered before a judge in a previous case, and of other court records maintained by the clerk of the court in which the judge sits. So just to be clear, we have, it's very common that you have litigation where things could be, you have a lot of related cases arising out of the same incident. And if a party has, if we have collateral estoppel from one case, or the judge wants to, let's say this is a sentencing case and the judge wants to see how many prior convictions does this person have, or cases in our courthouse on this type of offense. The judge, and it's in the court docket information in that courthouse that's available to the judge, that's okay. Court records can be judicially noticed for their factual existence, their occurrence and timing of matters like hearings held, proceedings filed, but not for the truth of the allegations or findings therein. Now, please notice when we say judicial notice, the judge is not just going to say, I'm going to keep that in mind. You actually have to come and put it on the record in the case and say, look, I just want to note that this person has asked for 27 continuances, and the last judge that this case was pending before is retired, and now it's been transferred to me. So the number of continuances filed in a case is kind of beyond dispute, but we're still going to put it on the record. I'm taking judicial notice of this. Standards of judicial notice require the judge give notice and an opportunity to be heard either before or after taking judicial notice. And again, each judge should determine the law of judicial notice in his or her jurisdiction. Here's our conclusion. Stated simply, a judge should not gather adjudicative facts from any source on the internet unless the information is subject to proper judicial notice. Further, and within guidelines set in this opinion, judges should not use the internet for independent fact gathering related to a pending or impending matter where the parties can easily be asked to research and provide the information themselves. And the same is true of the activities or characteristics of the litigants or the participants in the matter. Closing note for my students. It seems to me, but this is just my hunch, what prompted this was back in 2017 was a very well-known kind of celebrated judge on the Seventh Circuit Court of Appeals, Judge Richard Posner, was in fact violating this rule, was doing his own independent legal research and was actually putting it right into his opinions. And so there's some cases, for example, where Judge Posner on the Seventh Circuit writes an opinion, and he has gone to Google Earth to get a Google Earth picture of the accident scene, or the scene where the incident occurred, and says the party's description isn't right. Look at this image, this screenshot I have from Google Earth of the scene of the accident and the way the intersection is constructed and stuff like that. And so it's kind of a flagrant violation of this. And by the way, Judge Posner thought this rule was stupid and was very public about this as a dumb rule. Judges should get as much information as they can and make as accurate a decision as they can. So he thought it was kind of dumb to keep the judges in ignorance. Well, Judge Posner has since retired, and the ABA's response, even before he retired, it seems, was to put out an ethics opinion saying, we really mean it. On the other hand, to my knowledge, Judge Posner was not sanctioned or disciplined for doing this, but this was probably to send a message to other judges not to get any ideas and start doing this. That concludes our lecture on this particular ABA ethics opinion. Again, for my students, pretty good chance, several times this has been tested on the MPRE.